Hey, yo, folks. Welcome. Ashleigh Merchant. You might know her from the the Fannie Willis disqualification case. You might know her as the lawyer who showed up for Mr. Steele when Judge Glanville tried to hold him in contempt. She is also the attorney for one of the witnesses, Mr. Arnold, who is up in a couple of weeks, maybe. And she wrote a letter to the DA's office and to Miss Adrienne Luttrell Love. That's a warning. Do not F with my client, as you have done with other witnesses. Let's go into it. Let's have it here. Yeah. There's a hidden shade here. Before this video is finished, let me know in the comments if you see it, because it's a big one. And when you see it, you can't unsee it. Let's have it here. The Merchant Law Firm, Ashleigh B. Merchant, October 9th, 2024, Fulton County District Attorney's Office, Miss Adrienne Love, Assistant District Attorney, via email. This one, she put out. Okay. In response, State of Georgia versus Williams et al., witness Martinez Arnold. Dear Ms. Love, I hope you are well. Please allow this to follow up on our prior discussions in connection with Mr. Martinez Arnold's testimony in the trial of State v. Williams et al. Given that the state has sought arrest warrants in connection with other witnesses, I wanted to proactively reach out to you regarding the scheduling of Mr. Arnold's testimony so that we may avoid any last-minute scheduling issues and avoid a legally improper material witness warrant issuing for Mr. Arnold. In an effort for full transparency, I am copying the court and known defense lawyers on this communication. I understand the state would like to speak with Mr. Arnold prior to him taking stand at trial. But Mr. Arnold did not agree as part of his plea negotiations to allow the state to interview him. He provided testimony as part of his plea colloquy, and the state was free then to inquire of him, and it did. As a result, Mr. Arnold declines the state's invitation to talk with the state again prior to his trial testimony. In connection with his anticipated trial testimony, and as part of the plea negotiations in December 2022, I requested two things. One, that the state honor my leaves as Mr. Arnold's counsel of record, and two, that the state give Mr. Arnold and me advance notice of his trial testimony so that I could comply with my legal obligations pursuant to Superior Court Rule 17.1, which requires that I provide other courts with at least 7 days' notice of any conflicts. To be clear, my continued request for advance notice of the date the state anticipates calling Mr. Arnold is in no way a suggestion that he will not abide by the terms of his negotiated plea. He intends to comply with the terms of his plea, just as I hope you will comply with our agreement that you would provide me with advance notice of his date of testimony. While I have not followed the proceedings closely, I understand that the state recently has sought material witness warrants for certain witnesses, and my belief is that the state has done so without legal authority. I believe the state's arrest of Quindarius Zachary on September 16th constitutes a false arrest and would give rise to civil actions against you and others who effectuated his arrest. The order your office presented for your critical to sign reference an application for an arrest warrant for material witness with the criminal offense of OCDA 17-7-90. The statute, however, does not apply to witnesses, but only applies to criminal defendants and whether they appear for their own cases. For these reasons, I am writing proactively to ensure that you do not improperly seek a material witness warrant for Mr. Arnold. If you do, we intend to seek all remedies under the law as outlined below. As I'm sure you understand, there is no mechanism to obtain a material witness warrant for an in-state witness. But the state recently has sought such warrants for in-state witnesses. Material witness warrants are permitted in two instances. First, pursuant to OCGA 17725, attendance of witnesses. Quote, a court of inquiry shall have the same power to compel the attendance of witnesses as in other criminal cases, as set forth in and subject to all the provisions of Chapter 13 of Title 24, at any location where the court shall conduct a hearing, provided that notice is given at least 24 hours prior to the hearing. A court of inquiry may order the arrest of witnesses if required to compel their attendance. OCGA 177020 explains that a quote-unquote court of inquiry is a court with the criminal jurisdiction of a magistrate to examine an accusation against a person legally arrested and brought before him or her. These provisions clearly do not provide for the issuance of a material witness warrant before a superior court conducting a criminal trial. The second instance that a material witness warrant may be issued is when a witness is from without the state, which means not in Georgia in this case. Pursuant to the Uniform Act to secure attendance of witnesses from without the state, 241390, as Mr. Arnold is not a witness from without the state, this provision also does not provide for the issuance of a material witness warrant for Mr. Arnold. While the court retains the power to compel the attendance of witnesses, that power is enforced by quote-unquote attachment for contempt and not a material witness warrant. Subpoenas are enforceable by attachment for contempt and by a fine not exceeding $300 and or imprisonment not exceeding 20 days. In all enforcement cases, the court will consider whether under the circumstances of each case the subpoena was served within a reasonable time, but in any event not less than 24 hours prior to the time that a witness appearance was required. See also OCGA 15-1-3 provides general powers to the court to enforce compliance with its process. Clearly, the state has no power to seek a material witness warrant for an in-state witness at a trial before a superior court judge. The only power the state has to compel the attendance of a witness contained in 241326, which is not applicable at this time since Mr. Arnold is willing to appear even without a subpoena. While district attorneys typically enjoy immunity for acts undertaken in connection with their court-related duties, the 11th Circuit Court of Appeals recently denied absolute prosecutorial immunity for a Fulton County district attorney who obtained a material witness warrant for a witness and then failed to record the warrant after that witness testified. The court held that, quote-unquote, the arrest and confinement of the witness had nothing to do with conducting a prosecution for the state, and that the district attorney, quote-unquote, did not have to engage in advocacy to initiate the warrant's recall, but only needed to notify the judge. Therefore, the district attorney did not have immunity for the false arrest and confinement of this witness under a material witness warrant. If you choose to ignore foregoing law and seek a material witness warrant for Mr. Arnold, we are putting you on notice of our intent to pursue all remedies provided for false arrest and confinement as outlined in the Cass decision. We truly hope that is not necessary. I wish again to make clear that Mr. Arnold intends to comply with his obligations under his plea agreement, which included his rights against self-incrimination under the Fifth Amendment and the right to have me present in the courtroom with him when he is questioned by the state. I'm simply requesting that the state, as it agreed to do, provide me with advance notice for his testimony and honor his privilege against self-incrimination. Though we have not been able to talk about this in person given our schedules, I hope this clarifies my position regarding Mr. Arnold's testimony, and I look forward to your anticipated cooperation. Yours truly, Ashleigh Merchant. CC'd to the Honorable Judge Paige Reese Whitaker, the Honorable Simone Hilton, the Honorable Adam Abbott, the Honorable Brian Steele, the Honorable Keith Adams, the Honorable Max Short, the Honorable Doug Weinstein, the Honorable Jay Abbott, the Honorable Bruce Harvey, the Honorable Carton Matthews, the Honorable Lamar Gardner, the Honorable Angela DeWilliams. Now, did you spot the shade? Let's go up to the top here. Miss Adrian Love, Assistant District Attorney. Dear Miss Love, this is not addressed to the Honorable. It's nothing that addresses Adrian Lettrell Love as Honorable. Everybody else is. That's some shade. Now, when it comes to this, I've seen discussions online whether her argument is correct. I must honestly say I don't know. But sun is up. But she is prepared to do it, and she has it in writing. And apparently she believes in it, Miss Merchant. And Miss Merchant has destroyed prosecutors before. She is close to destroying Fani Willis' career. And if given the opportunity, she might destroy Adrian Lettrell Love's career as well. So that is the letter. Miss Merchant, or Mrs. Is warning the prosecution to don't F with my client. Do not F with my client. I will go after you for everything you got. And I think she will. If the state screws up, Miss Merchant is coming for you. All right. Thank you all for listening in, and you all have a good one. See you in another video or in another stream. And hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? See you. Bye-bye.